Good afternoon, everyone. Welcome to our August 12th webinar on all things leasing, regulations, limitations, and enforcement. My name is Alina Gilbert. I will be presenting today, and we've got a lot of stuff to cover. But before we do, let's do our usual housekeeping while you guys read this hilarious house agreement. So again, my name is Alina Gilbert. And on your screen, you should be seeing mostly the slideshow. So the house agreement should be the bulk of your screen, and off to the left on the side is me, the presenter. Hello. Off to the right, you will see an icon that says chat. That's what you're going to click on and enter any questions you have as we go through this. But just as an FYI, I will be saving the questions until the very end. First of all, I want to make sure we have enough time to get through all the materials, but also, a lot of times the questions get answered later on in the presentation. So it doesn't make sense to stop as they're posted. So we will save them for the end. If you are having any audio or video issues, you should see a little button at the bottom that says audio or video issues. Press that button. It takes you through a few steps and hopefully resolves whatever problem you are having. 1 CMCA credit will be issued for attendance at this webinar. You have to stick around through the end. It's automatically generated and it will be emailed to you. As a word of caution, if you don't already know this, please, when you get that email with your credit certificate, save the picture, save that picture to wherever you want to save it to on your computer. It does magically disappear after 30 days and you cannot get it back. So just make sure that once you get your email with your certificate, you save it so you can pull it up later. As a reminder, we are recording today's presentation. So if you just love it and you want to tell other folks to watch it, please feel free. It will be on the ACE YouTube channel. It'll probably even be there later today, but tomorrow for sure. The only thing is, if somebody's watching it on the YouTube channel, we cannot give them a credit for watching it, but they can definitely watch the whole presentation on the YouTube channel. Let's see, what did I miss? I don't think I missed anything. So just in closing, we are going to have a survey pop up at the end of the presentation asking you for feedback about the class. If you have time and the inclination, we always appreciate feedback. I don't care if it's good or bad. Whatever you want to provide to us, it helps us create better programs in the future. And speaking of which, 2027 education will be up on our website within the next month. So keep an eye out for it. As soon as it's up there, you can start registering. And we are going to have a whole bunch of really fun classes coming up. Well, fun for me, classes coming up next year. So just keep an eye out for it. So now, without further ado, we are going to go ahead and dive right in. So as always, let's look at the big picture of leasing. What is leasing? Do we inherently know what leasing is? Yeah, but it has several components that make it a lease from a legal perspective. And so what is it? Well, first and foremost, it is a right to possess property that belongs to someone else at their exclusion. So for example, if I'm leasing my home to someone, they are going to be living in the home and I am not. Even if I'm leasing a room to someone as my roommate, I'm still in the home, but I can't occupy that one room because they're living in there, right? So it's still at the exclusion of an owner. If I'm letting someone lease a parking space, then if it's my parking space, I can't use it because I'm leasing it to someone else. So it has to be at the exclusion of the owner. It is memorialized in a binding contract, which we fondly refer to as the lease agreement. And there is typically some sort of payment for the possession rights, and we call that payment rent, the magic word of rent. And finally, it's a finite period of time. Leases have terms. They may be subject to automatic renewal, but nonetheless, they are terms. They're not like for the rest of your life. They're not for, a million years. They are for a specific lease term. So in general, keep that in mind when we talk about leasing. This is really what we're talking about. We're not talking about situations where I'm just letting you borrow something and you bring it back. I'm letting you stay at my apartment for a couple of nights because you don't have anywhere to go. It's not that. It's a true definition of a lease. So I always ask folks, what do we care? What do we care if there's leasing in the HOA? Why is it a big deal? Why? And kind of the biggest thing that comes up, of course, is this idea that property values go down when there's too many leases. And is that reality or is that perception? I don't know. It depends, I think, who you ask. Some people say absolutely. If there's more leases than owners, nobody wants to buy and the property values go down. Others say not necessarily. So, but that is a perception and I hear it a lot. Now, what's not a perception is people's ability to purchase in a community that has a lot of leases in it. And that is because of requirements by secondary lending market like FHA, Fannie Mae, Freddie Mac. They all look at this stuff. And so if we have a large number of leases above the caps that they allow, then they are most likely not going to back a loan like that. And so therefore the banks will not loan that money to purchase in that community. What are the leasing percentages? Typically FHA is going to be 50% and VA is 45%. So kind of keep that in the back of your mind of how many leases do we have to have for it to really be a big negative red mark when it comes to lending money to purchase. And then there's, of course, the other big thing, which is the perception, again, that tenants don't care about the property. They don't follow the rules. I've heard people say, oh, when there's tenants, there's a lot of criminal activity in the community. All these bad things happen when we have a lot of tenants. And that's because, they're not vested in the property. They don't have ownership rights. They can, trash the place, move out and never have to deal with it again. They don't have a financial investment like a homeowner would, and therefore they don't care as much. Again, obviously that perception comes from real situations that people have, been subject to. I get it. But, as you also know, there's a lot of tenants out there that take better care of the property than the owners do. So, it works both ways, but nonetheless, that there is this perception that a lot of tenants means a lot of problems. And the other impact, and there's more than this, these are just the big ones, is that when we have offsite homeowners, when they don't live in the community, it's very difficult to enforce anything because we have to go against the homeowners and they're not here. So they, ignore our emails, they ignore our letters, they ignore our phone calls. They don't have to see us every day. So, they're not accountable for what happens in their units. They ignore us, as the HOA, and therefore, we cannot get a hold of them and we cannot enforce the covenants, right? So those are all impacts, whether real or perceived, that communities feel when there's a lot of rentals in the HOA. And I suspect if you're, sitting in on this webinar, you've probably experienced some of this, and that's why you're attending the webinar. So let's talk about restricting leasing and the process for doing that, because there's really only one way that's going to happen, and that's going to be by amending the declaration. You cannot enforce, or you cannot add leasing restrictions through rules or policies, resolutions. None of that can have any kind of rules or guidelines or requirements for leasing. It has to be in the declaration. Why does it have to be in the declaration? Well, I'll tell you, there's a few reasons. One is it is considered a use right, and it's a use restriction. There's a lot of uncertainty in the legal world about what constitutes an actual use restriction on the property. Does saying you can't have any dogs, is that a use restriction? And there's a lot of kind of competing views on this, but one thing that is certain that there really aren't too many competing views on is that leasing is, when you control leasing, it's a use restriction. And part of ownership is the ability to sell your property, to lease your property, to refinance your property. That is one of the essential rights of being an owner of property. And associations cannot just simply take that away or limit it through, imposition of rules, because essentially that would mean the board, a group of whatever, 3, 5, 7 people, are going to tell me that I can't lease my property, which is a fundamental right of ownership. So what Kiowa says, the Colorado Common Interest Ownership Act, what it says, and this applies to all communities regardless of when you were created, is it says that the board of directors cannot change use restrictions. That's a prohibition in Kiowa. So anything that constitutes a use restriction cannot be modified by the board, right? So it has to be modified with approval of the homeowners, and it has to be modified in the declaration, which is a recorded document, which means when I buy a home in your community, if the declaration says that I can't lease my home, and it's a recorded document, means I've noticed when I'm buying that I'm not allowed to lease my home, and I'm already agreeing to it by purchasing in the community with that notice that's out there in the real property records. Okay, so what Kiowa also says is, you guys know how we always say, hey, if you've got a homeowner approval requirement in your covenants and it's more than 67%, it's void, and it goes down to 67%. We always say that. There are some exceptions to that, and this is one of them. Kiowa says if you are changing a use restriction, you need at least 67%. So that's the floor now. You need at least 67% of your homeowners to approve it, or any higher requirement the declaration contains. So there are some older documents out there that say in order to change use restrictions, you need approval from 100% of the homeowners. You're stuck with that. You need 100% of the homeowners to be able to change leasing in that community. Because again, under Kiowa, it's 67% minimum or anything higher that the declaration prescribes. If the declaration says 90%, then it's 90%. If the declaration says you only need a simple majority of all the owners to approve any modifications, you're still at 67% if you're changing your leasing. So it is super important to always keep that in the back of your mind, because I cannot tell you how many times I've had boards and management submit rules to me for review, and in the rules, sure enough, there's leasing restrictions and there's nothing in their declaration. That you can't do that. It's not going to be enforceable. And again, you should only be focusing on having these types of restrictions in your declaration. So when you are adding leasing restrictions, what kind of restrictions are out there? Well, there's a lot of them, right? You can get super creative. I've seen all sorts of restrictions, but what we see typically are things like leasing caps. So no more than 30% of all the units in the association may be leased at any given time. Okay. I've had some associations actually use a number, no more than 50 units in the community may be leased at any given time. It's certainly up to the board as far as what type of an amendment it wants to present to the homeowners. So it can propose whatever it wants. You can propose a leasing prohibition, no leasing. No units may ever be leased in this community. We don't see that very often, but I have seen associations try to get that passed. It's highly unlikely that you would get that passed, but you could try. So, prohibiting short-term leases and vacation rentals. So no lease may be less than 6 months. No Airbnb, VRBO, leasing, or any other type of vacation rentals are allowed in the community. So you, of course, could have something like that, and that is a pretty typical restriction. Less typical, but I see it nonetheless, is requiring an initial lease term of a certain amount. So, for example, no owner may have an initial lease term of less than 12 months. So what that essentially does is, and you can fashion it in different ways. You can say initial lease term for each renter, which means you have to have at least a 12-month lease when you have a new renter. And then after that, it can renew monthly and be a month-to-month lease. Or it could be when you first buy in the community, your first lease cannot be less than 12 months. It just depends how you structure that. But I have seen folks adopt those kinds of amendments. I have seen a prohibition on subletting. So I lease my unit to Joe. Joe cannot now turn around and lease his interest to another person, right? It has to be just Joe. No leasing less than the entire unit. That's another one that I see used a lot to try and address situations where typically these are places close to colleges or universities where someone's trying to lease, like you have a 3-bedroom apartment or, condo unit, and they're trying to lease, a bedroom to 3 different people so that they can share the apartment. So that would be leasing less than the entire unit. You're leasing a bedroom. So I have seen that type of leasing, attempted to be prohibited as well. And of course, copies of the lease to the association, a requirement that when you're leasing, you got to give the association a copy of the lease. We, of course, have to allow folks to redact any kind of secure information like financing type stuff, social security numbers, anything that's private in nature. We do not have a right to demand that information. So we would have to allow redaction. I'm sure those of you watching are sitting here thinking, oh, I could think of like 10 other, leasing restrictions that I've seen my communities do. And I'm sure there's no end to the creativity of what associations have tried to do, when it comes to leasing restrictions. So, but these are just a few of kind of the big ticket things that we've seen. So before you go and start proposing all sorts of amendments with respect to leasing, I do want to talk about some FHA no-nos. And this is more of like secondary lending market no-nos. But there are some leasing provisions and language that you could put in to your declaration that would essentially be frowned upon by secondary lending markets, and would again result in potential purchasers not being able to obtain a loan to purchase in the community. So with the leasing caps, like I said, FHA is 50%. So if you have a leasing cap that's 55%, FHA is going to say, nope, not going to lend. We're not going to support any lenders in this area because 55% is over what we consider to be acceptable. VA is, like I said, 45%. So if you have a 50% leasing cap, VA is not going to support that and not approve any loans on that basis. So you want to be strategic when you're thinking about what kind of a leasing cap do I want? Do we need? I will be honest with you and tell you what I typically see is between 25 and 35%. The reason is that, you have to think ahead and think that, okay, let's say we get to the 35% leasing cap. And what do we do if someone has a true hardship? They're being relocated for work. They're trying to sell the home and they can't. Are we really going to tell them they cannot lease their unit when this has nothing to do with anything they did wrong, right? They're not just trying to lease it because they want to. They have to move and they can't sell it. So what are they going to do? So, we'd always have situations where true hardships can come up. And so you want to have a leasing cap that allows for a cushion of at least 10%. In case we do have those kinds of hardships, to allow those folks to be able to lease and then still keep us under the caps set by FHA and VA. So that's why we typically see between 25 and 35%. I've seen less than 25%. I've seen 10%. But the general consensus is 25 to 35%. You cannot require a minimum lease term of less than 30 days in the declaration, which means you can't say that no leases less than 15 days will be allowed. That's all well and good, but that means you are allowing leases that are between 15 and 30 days. And the FHA considers any lease under 30 days to be a short-term lease, which it will not approve any loans for if we allow those leases that are less than 30 days. So you want to be careful also with how you set your minimum lease terms. And then finally, restricting who is eligible to lease in the community. In other words, telling the homeowners who they can and can't lease to. So for example, this is actually a real thing. Years and years and years ago, there was an HOA, I think it was in California. They amended their declaration to say you cannot lease to attorneys, or you cannot sell to attorneys. You cannot lease or sell to attorneys. Can't blame them for that. I get it. I wouldn't want attorneys in my community either. But if we had something like that, in our documents, you are not going to get secondary lending market support, and homeowners, or not homeowners, prospect purchasers would have a really hard time getting financing. So unless they were paying cash, you would not be able to sell units in your community. So those are the types of things that you want to avoid when you are amending your declaration, because any of these things would trigger a no loans type of a situation and no sales. So keep that in mind as well. The other thing I want to talk about is the difficulty in trying to enforce leasing restrictions. I think if you're going to try and push leasing restrictions, you need to also be aware of the practical side of that, which is enforcing those. And Colorado law is not at all conducive to successful enforcement of leasing violations. That I will tell you right now off the bat. And we'll talk about why. So for those of you who enforce restrictions in your communities, and I'm sure that's all of you, you probably have been already stuck in a situation where you have a violation and you send your courtesy notice or your 30-day demand notice, but the violation stops before you ever get anywhere with that, right? So for example, someone's leaving their trash can in front of the house. That's a violation. We send a note, they move it, and they've cured the violation. So if tomorrow they put out their trash can again, what we are stuck doing under Colorado law now is we got to start the process all over again. We got to send them whatever our, that courtesy notice or the first 30-day notice, whatever our enforcement policy has. So essentially what's going to happen is we're never going to get to the part where we fine them or we turn an account over to legal to start some sort of an enforcement action. So if you have, this is especially true when we talk about short-term leasing and Airbnb type vacation rentals, because those are usually what? A weekend, they're less than 30 days, right? And you got to send, now under Colorado law, before you can turn any enforcement action over to legal counsel, you got to send them at least 2 30-day demand letters, no more than 7 days apart, telling them that, hey, you need to cure the violation. What Kiowa says is, once they come into compliance, it's considered cured. That violation is done. We have to send them something saying your violation is cured. So when they do it again the next day, again, it is a brand new violation and we're starting from scratch. So what happens with short-term rentals, for example, is someone's leasing their unit, let's say it's even for a week, as an Airbnb. They lease it for a week. We send the letter saying, hey, you're in violation of, the declaration. And by the time we send it, they're gone. The renters are gone because they were only leasing it for 7 days. So now the violation's cured. You cannot impose the fine. You cannot turn it over to legal. You got to close it out. Oops. Okay. So next weekend, we got a new set of renters coming in who are leasing it just for the weekend. All right, we're going to send them another letter, but by the time the letter gets there, guess what? They're gone too. So that violation's been cured, and so on and so on. And so anytime we are dealing with some sort of a short-term leasing violation, we do have this difficulty of, sure, we can send the demand letters, but we never get to that next step. And that's very frustrating, and it makes things very difficult. When you have, let's say you have someone who's leasing, for a year. Okay. But we have reached our, 35% maximum leasing. And we find out, hey, someone actually entered into a lease for their unit after that without going through the proper channels. And now we've exceeded our cap. And this person is in violation because they went and leased when we were at the cap. So now we're trying to enforce that. So the timing with that one is okay, right? We can send a 2 30-day demand letter 7 days apart because that renter will still be there if it's a 12-month lease. But now we get to other parts that are difficult, which is how are we going to prove that violation? What are we going to say? We see someone with suitcases who moved in. We know what the real owners look like, and that's not them. How do we prove it? So you're standing in front of a judge. Judge says, okay, so the homeowner's there. The homeowner says, I'm not leasing my unit. I've got some friends staying there. They're not leasing it. They're just staying here for, a few days. How do we prove that they're actually leasing it? If we don't have a copy of the lease, the owner says, I have no lease. There's no lease. They're just friends, staying here. What do we do now? That's a difficulty. That's a practical difficulty. And then ultimate result. What do we want the ultimate result to be? Are we telling this owner that they need to evict their tenant because they improperly leased their unit when we have a cap? Is a judge really going to order this homeowner to do that? In most cases, no. Judges are very sympathetic to the renters. And also there is a law in Colorado that says you can't terminate a lease mid-term because the landlord screwed something up. So we can't force him to terminate that lease mid-lease term. And what do we do now? So kind of what is the end result that we are trying to obtain? And is it realistic? Are we going to be able to get it? So you see how having leasing restrictions is not the same thing as being able to enforce our leasing restrictions. And I think that is a difficulty that a lot of boards don't foresee, and they don't have that conversation with legal counsel ahead of time, talking it through, saying, are you ready to be able, to have to deal with all these practical difficulties? Communication with offsite owners, we have mentioned that before, right? So how do you, if the renter is doing bad things, we can't, we got to send our violation to the homeowner. Your renter is doing bad things, homeowner. What are you going to do? You need to take action, or we're going to go against you, homeowner, for violation of the covenants. Well, let's say the renter's making a lot of loud noise. Okay. They're throwing parties at night. Well, once last night's party is done, the violation is cured. The noise breach has been stopped. They ended the party. So when they start their next party tomorrow night or the day after or next weekend, it's another brand new violation that we got to start from the very beginning. So what are we doing? We keep sending the homeowner the same courtesy letter over and over and over again, and we don't get to the point where we're turning it over to legal counsel or we're imposing fines. We're not making it hurt. And so what incentive is there for this homeowner now to assist us or to try and evict his or her tenant? There's not a lot of teeth there. So that's another difficulty. And the thing that I always want to bring to everyone's attention, both boards and community managers, is when you have restrictions, you do have a duty to enforce them as a board. You can't just say, we're going to ignore this one. We're going to ignore this covenant. It's easier with the rules. If you've got rules you don't want to enforce, change your rules. Typically that's done with just a board vote. But if it's in your covenants, like the leasing restrictions have to be, you can't just get rid of them. You can't just change them. You're going to have to go through another amendment process with at least 67% of the owners approving it. So it's hard. It's very hard to change these restrictions once they're in place. So this is something that really needs to get thought out by boards before moving forward with amendments proposing, these types of restrictions. And again, if you're not having these in-depth conversations with your, attorneys and internally, you really need to be, because it's difficult these days. It's very difficult to enforce. So keep that in mind. So the next part of the presentation is I want to talk about problem areas when it comes to enforcement, or not enforcement, just problem areas in general when it comes to leasing restrictions. So some of them we've already covered, some we have not, but one is, trying to regulate leasing through the rules. As we discussed earlier, leasing is a use restriction. It can only be controlled through the declaration, and it cannot be imposed just by the board. You need to go through your homeowner approval process of at least 67%. How many of you have different rules for renters than for homeowners? I see this quite often. I've seen rules where if a homeowner has a pet, that's fine. If a renter has a pet, they have to pay a certain pet fee for it. I have seen situations where homeowners were okay to have pets, renters could not have pets because they were renters. So what is the harm in that? What is the harm in treating our renters differently? Well, the first thing is you always want to make sure there's nothing in the declaration that would limit our ability to treat renters differently. But the other thing is you kind of have to look beyond like what's in front of your face and think of the unintended consequences here. Because what could happen is if you have to look at the demographics in the community. If renters tend to be someone in a certain protected class. So it's a certain, certain heritage, certain, class, certain, protected class. That's all I can say. Yeah. And that's who tends to be our renters, while the homeowners tend to not be in that protected class. What's going to happen is you are going to get accused of discrimination based on fill in the blank: race, national origin, whatever, religion, I don't know. So you're going to have, and there's been cases like this, not so much in Colorado, but there have been cases around the country. And I can think of one specifically where a court said, you have different rules for renters than you do for your homeowners. Looking at the demographics, your renters tend to be minorities, while your owners are not. Therefore, your rules have a discriminatory impact on a protected class. These minorities are in a protected class. You may not have intended to discriminate against them, but you have the impact of treating a protected class differently than other people who live in the community. And it doesn't matter if you intended it or not. Intent does not matter. If you have a discriminatory impact, you are discriminating. And that association lost, and it was found to be acting in a discriminatory fashion. So I'm not saying it happens all the time, but certainly anytime you have different rules for renters than for owners, or you treat your renters differently than you treat your owners, you are exposing yourself to that claim and to that liability, which is why best practices dictate we do not treat renters any differently than we treat owners. Boards that approve renters. I have had boards they want to propose amendments, or sometimes they put it in their rules, saying that before an owner can rent, that the board needs to review the tenant and approve them. Yeah, that's a big, huge no. I don't know if any of you on this webinar have done this, or know someone who's done this, or want to do this. Don't. Absolutely do not do it. First of all, we already talked about impacts with respect to secondary lending markets and financing when we talk about who can rent. The other thing is, if the board is approving the renters, the board becomes responsible for actions of the renters. You approve a renter who then goes on to harm people. You, as the board and as the association, are exposing yourself to liability because you approved this individual to rent in the community. And you did not do your due diligence when approving them, because clearly they're not good people and they're hurting other people and they're committing criminal acts or whatever. You have now exposed yourself to liability, and you've essentially said that by approving this renter, you are vouching for them in some fashion. So don't ever, ever, ever try to set up a plan where the board gets to approve or even review renters. By the same token, don't require your owners to conduct background checks on prospect tenants. You can strongly suggest it, but you cannot require it. If you require it, you, again, as a board and as an association, have to enforce that. How are you going to enforce that? Okay, well, what are we going to say? You have to give us a copy of the background check. What if a homeowner doesn't give it to us? They rent it anyway. Person goes on to commit a crime. Worse yet, homeowner says, I have conducted a background check. They rent the unit. Turns out they lied. They didn't conduct it. And now this person's committing criminal activity. Oh, I guess we didn't really enforce our requirement that they conduct a background check. Now, I know this may all sound really ridiculous from a common sense perspective of, how can we make sure everyone conducts a background check? Well, you can't, but the law doesn't care. If you are requiring it, the law says you've got to enforce it. And the question is going to be, did we reasonably enforce this? And if we didn't, we are now exposed to liability because we did not enforce our rule. And now we've got people getting hurt, we got property damage, whatever it is. So no, we don't ever want to have a situation where our boards are involved in choosing the renter, approving a renter, requiring background checks, none of that. You don't want to have anything to do with that. All we can do and should do is just give some recommendations. We recommend you do a background check. Okay. That's it. All right. What else? Obtaining owner approval for proposed amendments, adding leasing restrictions. That is a problem area because it's difficult to get homeowner approval. When associations present these types of amendments to their homeowners, and for those of you who've done it, I'm sure you'll agree, there are essentially two primary views on this. One view is this is good because it'll limit the number of rentals and we'll have less problems and have higher property values. That's view number one. View number two is this sucks because I, as a homeowner, have a right to lease my unit and I don't want anyone telling me I can't lease my unit. Oh, and if I want to be an investment owner, you can't tell me I'm not. I can't do it. So those are the two schools. Yes, it's good because less renters. No, it's bad because although I want less renters, I don't want you to tell me I can't rent my home. You can tell everyone else, but not me, So those are the two opposing views that we get. And who's going to win? Who knows? But remember, we need 67% at least. So if you've got more than a third of your homeowners who are already in the camp saying, no leasing restrictions whatsoever, you're not going to get it passed. So you got to know your audience before you go down the road of spending legal fees to create these types of amendments. How do you know your audience? I would say, and I always say, look, do a straw poll, not a vote. Do some sort of a, survey monkey thing with an email that says, the board is considering, presenting an amendment that would impose a leasing cap of 25%. If this was presented, would you be in favor of it or against it? Make sure it's very clear. This is not a vote. This is not a formal vote on an amendment. This is just us trying to gauge, where the community is at any given point and whether or not it's even worth our time and money to go down the road of having an attorney prepare an amendment, for the homeowners to vote on. If you're getting mostly no's, I think you have your answer right there. Save the money. Don't spend it on us. If you're getting a whole bunch of homeowners saying, yes, please, we really want this, maybe it's worth it at that point. But again, there's no guarantees, right? You just never know what you're going to get. You may have people on the straw poll saying, yeah, I really want this. And then when push comes to shove and you present it, they vote no, because someone has gone and talked to them and given them a horror story of all the bad things that could happen if they approve this amendment. So obviously it's no guarantee, but you do want to at least gauge where your homeowners are at, because it is such a political topic, I would say. And a lot of times I've seen associations who are trying to rewrite their entire document have to remove all the leasing language that they put in because there's no way they were going to get the approval they needed for the governing documents with that language in there. So homeowner approval is definitely a problem area for associations in the sense of getting that approval. I have seen associations try to impose additional fees against landlords. I've recently even reviewed policies for a couple of associations where they, sometimes we see it in the term of a move-in, move-out fee. Sometimes it's more of if you're leasing your unit, you have to pay a leasing fee to the association. I mean, it's couched differently, but be careful with that. The board can't just impose these types of fees. There has to be authority for it. I had a manager email me not long ago saying, so where is there a statutory provision that says you cannot impose these fees on landlords? I said, you're asking the wrong question. The question isn't where is there a prohibition on it? The question is where is there authority for it? Because an association does not have unlimited authority to impose fees for whatever it wants. Its right to charge comes from two places. It's statute or it's your governing documents. And if neither cover that, and I'll tell you right now, Kiowa does not talk about specifically charging fees to landlords. Okay, so if there's nothing about that in your declaration, you are going to be challenged and you're probably not going to be successful when you try to impose these fees. Now, of course, it is going to depend on what kind of language you have, and maybe you have some broad authority to charge fees for other things that, can be used as an argument. That's a possibility, but you would need to check with the attorney for that community before doing it. So if you are thinking of imposing fees against your owners who are leasing units, I would really, really recommend reaching out to the association's legal counsel and having them look to tell you whether or not that's something you can do. Okay. Sending demand letters directly to renters. So that actually can be a huge problem. I have boards tell me, well, I'm sending it to the homeowner and copying the renter. Okay, well, here's the problem with any of that is there is a thing in Colorado in general in the law called interference with contractual relationships. And what that means is someone who's not a party to a contract is interfering with either party's ability to, fulfill the contract or to have the contract be in place or somehow interfering with performance under that contract. When associations send letters directly to renters, it is and can be considered technically an interference with the lease agreement, which is a contract. So if you don't have written approval from the homeowner to communicate directly with the renter, when you send violation letters directly to the renter, whether or not you're sending one to the homeowner, you are technically interfering with that contractual relationship between the homeowner and the renter, because the renter could be like, screw this, I'm moving out. I don't need this harassment. I don't need these letters coming from the association. And they move out. And we have had owners actually start asserting this sometimes in court. So people are getting wise to this, which is why the rule of thumb is do not send letters directly to your renters unless you have something in writing from the homeowner saying, yes, you can directly communicate with my renter, including, violations and things like that. Otherwise, you're just running the risk of somebody claiming that you're interfering with a contract and suing the association on that basis. Finally, not consulting with legal counsel. That is a huge problem area. Too many times have people brought their attorneys in after the deed is done, so to speak, and it's too late to get you out of trouble because you've already done what you shouldn't have done, or you've already tried to enforce the rules you never should have drafted to begin with. So it is super important. And I would just say when you're thinking about anything to do with leasing, I would always run it by legal counsel, just because it's a very inherently protected right of ownership, of property ownership, is your ability to sell, to lease, any of those things. So be careful with that. If you are having issues, please reach out to your community's council. talk it through with them. Make sure you have these conversations about not just the legal side, but the practical side, because the practical side makes a big difference. So there's always the legal answer, and then there's what's the reality of the situation? How does this play out in real life? Even if it's allowed by the law, does it play out in real life in a way that may make me more miserable and more exposed to liability than if I had left this alone? Okay. So those are my words of wisdom. I will now let you look. If you have a fear of heights, don't look at this, because I'm looking at it. I'm like, I don't like heights. All right. So I'm going to go through questions. We got 10 minutes, which is perfect. I'm going to start. I am going to start at the bottom here. I just got to find my little mouse clicky here. There we go. Maybe I can find it. I don't know. Help. My mouse is not working. Wait. Here we go. Figured it out. All right, I'm going to start at the bottom. We use the term lease. Does this include short-term rentals? Yes, and we talked about that. If you are a pre-Kiowa community, do you still have that 67% minimum to implement the restrictions? That is a great question. I want to say yes. I do believe it applies to pre-Kiowa communities as well. I assume a rental prohibition would also require a minimum of 67% approval like the leasing. Is that correct? Yes, it still falls under the term leasing restrictions. No leasing less than the entire unit. What about leasing to a roommate? How is this different? Yeah, so that's a great question. When we talk about leasing restrictions, one conversation that your attorney should have with you when you are talking about these restrictions is, what do you want to define leasing as for the purposes of the leasing cap? The way I draft it, unless the board tells me otherwise, is I say, so for the purposes of this declaration, leasing will not include leasing to a roommate where the owner continues to reside in the unit. I put that in there because I want to make it clear. But some boards may say, no, we want that prohibited, or no, we want that to be counted towards the leasing cap. And so it's a discussion that you have with the board of, are you okay with roommate situations or not? We also like to say that if you have your parent or a child, sometimes grandparent, grandchild residing on the property, that's not considered leasing. But again, that is going to be completely up, to the board to determine, whether or not they want to do it that way or not. So it is a preference, and it's in all how you draft the provision. Let's see. Do second homes fall into the percentage of rental units, or is it not included in the percentage or treated as an owner occupied? So the question would be, who lives in that second home? Are they renting it out to someone or not? Or is it that they live there part-time and they live somewhere else part-time? That's okay, because what we're looking for is, first of all, do they have a lease? If we're looking about true leases, or do they, what the secondary lending markets actually look for is, is this unit occupied? Is this an owner occupied unit? There you go. Couldn't figure out the best words. Owner occupancy. So it doesn't have to be 100% of the year, but I would say, if you've got something that's vacant and nobody's ever there, I would say it's not owner occupied. It's not leased, but it's certainly not owner occupied. If someone's residing there 6 months or more during the year, I would say it is owner occupied. Assuming it's the homeowner who's living there. Do hardships have to be listed in the declarations, or is there verbiage that states it's negotiable if it's a hardship? So it depends how that's drafted. We typically, when we draft it, we give examples of hardships, but then we also say, and the board can adopt, additional rules and policies further, defining the term hardship and, discussing what it means. So it just depends on how, you choose to draft that. All right. How do you think FHA feels? I don't think FHA feels anything. They're mean. No, just kidding. How do you think FHA feels about special events licenses Boulder now has for Sundance? I don't necessarily know if they care. I've not read anything in the FHA guidelines specifically addressing this, so it may not even be on the radar. That would be my guess. Oops, sorry. Does the ad run? Oh, does the ad running on the Airbnb site constitute proof that they're leasing short-term continuously? That is a really, really good question. And the answer is no, it does not. Just because they're advertising it doesn't mean they're actually leasing it. They may not be getting any bites. And so we see this a lot in our enforcement department where an association asks us to enforce something and we're like, well, where's your proof? It goes back to proof. Well, here's the ad. Judge is going to look at that and say, well, so they're advertising it, but you need to prove that they're actually leasing it. This doesn't prove they're actually leasing it. This might go to intent, but it doesn't go to the actual deed. So that in and of itself is just not going to do it for us. Okay. How do town ordinances and following those ordinances regarding complaints affect Kiowa enforcement provision, 30-day cure period? Well, if a lot of different stuff going on there. So town ordinances, associations don't enforce town ordinances. They shouldn't be anyway, unless your declaration says the association has to enforce town ordinances. And sometimes we have stupid language like that, which I hate. But you understand, associations are not code enforcement. The only thing associations can enforce are their own restrictions that are set forth in their covenants, rules, regulations. So to the extent we have, to the extent we have an ordinance in the town that says in order to lease Airbnb, you need to have a license. But we as the association have a flat out prohibition on it, right? We can enforce our flat out prohibition, assuming we can make get beyond the difficulties that we talked about. But it would be up to the city or county or whatever to come in and enforce where, if someone is doing a short-term lease without a license, then they would have to come in and enforce that piece of it. So it's really two different entities enforcing two different things, if that makes any sense. Let's see. Sorry. Last one, I think. If an owner is allowing two relatives to live in their condo without a written lease, and the owner is not living at the condo, but in New Jersey, and the owner has not changed their place of residence to the new condo, and 3, the association only has 10 leasing permits since they have a rental leasing cap, and 4, owner denies that this is a lease, even though the occupants are not on the title. What process can be followed if the owner continues to deny this is not a lease situation? You may not be able to do anything in that case. I think it depends on a lot of different factors that would come into play when you have a discussion with the attorney who represents that community. The end result is if we have to be able to prove a violation, and if we can't prove a violation, there's nothing we can do, right? We can't go to court over it. You can try to send the demand letters, you can try imposing fines, but when push comes to shove, if the end result is there's a long-term lease and it's outside the leasing cap that we have, we need to be able to prove that there's a long-term lease in there. So that was where the attorney would come in, because they could try to figure out, based on the circumstances, whether or not there is any, documentation that would help us establish that. So it just depends on the specifics of the case, unfortunately. Okay, it's 1:00. Thank you all so much for joining me today. And if you have time to do the little survey, I would really, really appreciate it. Thank you, and we'll see you all next time.